Okay, welcome back, everybody. We're going to turn it over to Leslie to talk about legal and liability. Um, so take it away, Leslie.
All right. Good morning, everybody. Thank you for being here and letting me be here. I know it's the end of the week. I know you've seen a lot of the presentations, but I will tell you that the next couple hours are probably the most personally relevant to you yourself. And that's because we're talking about your pocketbook, we're talking about your freedom, we're talking about your job. And the possibility of losing money, losing your freedom, losing your job over something that you did while you were on the job. So with that, I'm going to talk a little bit about this. So even though I've kind of gotten your attention, there is overall, there's a very low risk to be held personally responsible for damages for actions while a federal employee. Okay. The system overall is designed to protect you. So everybody can kind of just breathe. All right. Otherwise, no one would be a federal employee. I mean, when's the last time you heard of somebody having to pay a judgment or for something that happened at work? You probably haven't. You've never heard of anybody in the fire context going to jail, and we'll talk about that. The other thing is Department of Justice representation is almost always available to you, so you don't have to hire your own lawyer. And the other thing is powerful legal defenses can be raised on your behalf. You are an arm of the federal government, and as we'll learn in this presentation, it's very difficult to sue the federal government. There are defenses that the government can raise on your behalf that couldn't be raised in like a case with two private parties. And the other thing that I think should help make you feel a little better is we're moving from an investigation-based culture, sanctions-based culture, where we're going to fire you for losing that prescribed burn, or we're going to do this, you're going on leave, or you're doing this, to a learning-based culture. The federal agencies are looking at what can we learn from our mistakes instead of what are we going to do to this person because they screwed up. So today we're going to understand the risk for personal liability. We're going to understand why in the majority of cases that risk is low. And we're going to talk about the actions that you can take to keep that risk low. So, I ask you, think about it right here. In terms of personal liability, right now, what keeps you up at night? Okay, what keeps you up at night? And then afterward, I'm going to ask you the same question, because the bottom line is you have to somehow come to terms. I can't tell you that all risk of personal liability is going away. I can't do that. There's always that possibility. So you yourself as a line officer or a fire management officer, you need to come to terms with that risk. And how are you going to deal with that? Are you going to get personal liability insurance? Are you going to, whatever? Because you have to take risks on that job to be effective. And a little bit about, and you're thinking, well, why is this attorney telling me this? Well, a little bit about me. I'm a retired forest supervisor. I was a forest supervisor in the Huron-Manistee in Michigan. I was an attorney for the Forest Service for 15 years. I've been involved in fire since 2006. I'm a type 1 PIO, and I go out as an AD now. And when I left the government, I was a journey level agency administrator. And maybe most important was I signed off on a burn that escaped. So I'll tell you a little bit about what happened to me later. But the point I guess I'm trying to make is that I've been where you've been. And the advice I'm going to give you today is the advice I would take myself. I can't see the chat, so if there's questions, just let me know, and or you're welcome just to raise your hand, and I'll answer questions, that's fine, or if there's questions in the chat, let me know. I can also, as we go through every so often, I'll just say, are there any questions? And we'll just go from there. But you're certainly welcome to ask a lot of questions. The other thing is I have to talk about some legal concepts, but I try to pare this down to exactly what you need to know. And I try to give you very relevant, when I introduce a legal concept, I try to give you a lot of examples, both from your personal life or in the fire context. We're going to talk about the burn boss that got arrested for reckless burning the last year or 2 years ago. We're going to talk about the 30 Mile fire and that IC that was indicted for involuntary manslaughter. We're going to talk about the Kramer fire. So we're going to talk about all of those things here and try to get these legal concepts to, real examples that you can understand instead of just talking about it, kind of an esoteric way. So with that, we're gonna talk about 3 things today. We're gonna talk about civil liability, we're gonna talk about criminal liability, and we're gonna talk about administrative sanctions. And the rules are different for each. Okay, so we're gonna take these one by one. Civil liability is the longest section because some concepts are introduced that are later going to be used in criminal liability, et cetera, et cetera. So I'm going to try and get through civil liability, but if it appears you all need a break before civil liability ends, I'll do that as well. I'll try to find it. But the natural break would really be after civil liability. So with that, let's talk about civil liability. What do we mean by civil liability? We mean you're going to have to pay money out to someone for something that you did and you injured that person or you injured that person's property. This could be in a personal context, or we'll talk about it in terms of government fire context, et cetera, et cetera. That's what we talk about mostly when we talk about civil liability, is paying money out of your own pocket. So what do we mean? We're talking about torts. And I'm sorry, I've got to give you this legal definition, but it's a legal wrong. A private or civil wrong or injury other than breach of contract for which the court will provide a remedy in the form of an action for damages. And damages mean money. So I mean a legal wrong. And what's the difference? We do bad things to one another all day long. But the courts have recognized that certain things you do to one another, if you do that to someone and they are personally injured or there's damage to their property, you may need to compensate them for what you did. And here's some example of torts. Trespass. You own a nice piece of property. Someone comes on that property with their ATVs and wrecks it up, and you never gave them permission to do that. They're guilty of trespass. The same thing in a government context. If we accidentally are doing if the government's doing a timber sale and accidentally cuts some trees on private land, that's trespass. We may have to pay for those trees. Assault and battery, nuisance. Nuisance is someone depriving you the use of your property, the enjoyment of your property. And the classic law school example is you own a nice piece of property, and in back of that property, someone comes in and they buy that property and back you, and they start a pig farm. And the stench of that pig farm is so great that you can't go out on your patio at night and relax. It may even be permeating your house. That's nuisance. That means that they've done something to you to prevent the enjoyment of your property. Intentional infliction of emotional distress is another tort. Libel and slander. Someone lies about you whether they wrote something or said it or whatever, it damages your reputation. Invasion of privacy. Now, this is a theme that I'll carry through in terms of this is a tort that's changed over the years. okay? You know, 35 years ago when I was in law school, invasion of privacy had to do with the peeping Tom that puts the camera through the fence and takes pictures of you, or someone goes through your garbage. Well, as society morphs, the law morphs. And invasion of privacy today is what about? Social media stuff. People posting social media pictures of you that you didn't want posted. So that's how things change. And the law changes. And the law with fire is changing as well. Wrongful death, we'll talk about that a little bit more in the criminal context later on. But the tort that's most relevant to you in the context of fire is the tort of negligence. And negligence is really failing to act in a reasonable manner. And there's 4 elements of negligence. And I'm going to give you I'm going to give you a lot of examples of this. The employee has a duty to act in a reasonable manner, and the employee breaches that duty. And as a result, there's personal injury or property loss. And the employee's breach of duty was the actual cause of the damages. So you've got a duty, you breached that duty, and as a result of what you did, someone's injured. So let's give some examples. First, we'll do it in the private context, and then we're going to talk fire. So running a stop sign. You get in your vehicle and you accidentally run a stop sign, whether you were just kind of just spaced out, maybe a tree was covering the stop sign, maybe you went down to change the radio, whatever the case may be. You just accidentally ran that stop sign, and there's an old lady that is crossing the street and you hit her and injure her. So you had a duty to stop at that stop sign, the law says it, and you breached that duty. And as a result, the old lady gets hit and injured. That's negligence. Medical malpractice is almost always, no matter what, it always involves the tort of negligence. You go in, you have to have an operation, and the surgeon leaves gauze in you or leaves an instrument in you, and as a result, your body's damaged. That's negligence. The doctor had a duty to operate in a safe and reasonable manner and not leave something in you. They breached that duty, and as a result, you're injured. Now, as I said, the law changes as society changes. Pra versus Moretti was the very first solar power case ever in this country. It was in the late 80s. It was out of the Supreme Court of Wisconsin. And Mr. Pra and Mr. Moretti lived next door to one another. And Mr. Moretti decides to put a second story on his house, and Mr. Pra had solar panels on his house. And the second story of Mr. Moretti shaded those solar panels such that they weren't very effective. This was the first time a court looked at this kind of thing in terms of solar power. And the first thing they said was, okay, do you as a landowner, with your bundle of rights that you have because you are a landowner, have the right to light in your house? And the answer was yes. They looked back into the 1600s, 1700s, legal precedent, etc. And you do have that right. So as it wasn't a whole lot of farther stretch to be able to say, okay, Mr. Pra had the right to have the solar panels function. And therefore, Mr. Moretti had a duty to not shade those. And he breached that duty. And as a result, Mr. Pra was injured, and Mr. Moretti is now going to have to pay him for that injury. So, example of, again, the law starting to morph as society morphs. But let's talk about, here's an example. This is a real life case, and it has to do with a prescribed burn. And this is what the court said. It said, first of all, the burn boss had a duty to use reasonable care in carrying out the prescription set forth in the prescribed burn plan. The burn boss breached this duty by failing to consider the weather forecast, which predicted warming temperatures and high gusting winds. So He didn't do it. Whatever happened, the burn boss, you know, went ahead with this burn. And as a result, the burn got out and it damaged the plaintiff's property in the amount of $15,000. And obviously the failure to look at that, those warming temperatures and the high gusting winds was what caused the damage to plaintiff's property. So there's an example of negligence in the fire context. Okay, so I'm talking very generally about negligence, but you're sitting here and you're thinking, okay, when is the government liable for negligence actions? And most importantly, when can I personally be liable for, you know, actions that I took? If I do something wrong on the job, when am I going to be personally liable, and when am I going to be immune from liability? So let's talk a little bit about, first of all, government immunity, because you're an arm of the government. And we're going to take a trip back into history. So our system of laws came from England. And England was ruled by a king, a sovereign. And in England, the king was immune from liability. He could do no wrong. No one could sue the king. And that idea came over to this country. The idea is that the government wasn't liable for its screw ups. It just wasn't. Unless, and the only way the government was going to be liable was if Congress said they were liable. Okay. So Congress could waive the sovereign's immunity. You could say, in these circumstances, the government's going to be liable. Okay. But at one time, like say 1944, if you were driving a Forest Service vehicle and you ran a stop sign and you hit someone and injured their vehicle, there was no government liability. And the only way that person who you had hit, the Forest Service or the Park Service or whatever agency that was involved here, could not pay that guy or that woman for the damage to their vehicle. They couldn't, because there was no government liability for such things. So the only way they could get paid was to go to their congressman and say, I need $500 for the damage that the Forest Service caused to my vehicle. And the congressman would have to get a specific bill passed in Congress allowing you to have that money. Obviously, that took a lot of effort and it wasn't very efficient, et cetera, et cetera. So Congress in 1946 passed the Federal Tort Claims Act, and it made the government liable for actions by the United States or its employees for negligent or wrongful acts or omission in the same manner and to the same extent as a private individual under like circumstances. So it made the government liable for negligent acts. And liability is determined by the law of the state where the injury occurs. And this varies from state to state. So you look at the law of the state. So if you have this, going back to our stop sign example, today, if you're driving a government vehicle in Michigan and you run a stop sign and you hit somebody else's vehicle, in Michigan, we have what's called the no-fault law. And when there's an automobile accident in Michigan, each party looks to their own insurer, okay, to pay for their damages. They don't sit there and litigate it in court and decide and argue who is liable, who was not, who is negligent, who is contributorily negligent. For the sake of efficiency in Michigan, everybody's got to be insured. And if you get hit by somebody, even if it's not your fault, you just look to your insurer to pay your damages, and the other party looks to their insurer. So if you're driving a Forest Service vehicle in Michigan and you hit somebody or any kind of government vehicle, the government is not authorized under Michigan law to pay for that party's damages. Now, if the exact same accident happens in Illinois, Illinois has the ordinary law of ordinary negligence, and the government agency would pay for that party's damages. It just varies from state to state. Now, one thing I want to bring up, I thought I saw that there were a couple federal, state employees here. And I just want to bring up that every single state has its own version of a Federal Tort Claims Act. And so what I'm telling you here pretty much probably applies to your state. In fact, I think in the state of Washington, I looked it up once, and I think your Tort Claims Act actually has the exact same wording as the Federal Tort Claims Act. So the concepts that I'm talking about here, even though I'm talking Federal Tort Claims Act, it very much applies because your state probably has an act that's very, very similar to this one. Okay, so we talked about when the government could be liable. So the government assumed liability for the negligent acts of its employees. Okay, but when it assumed that liability, what it also did was, in the Federal Tort Claims Act, it made federal employees immune from liability for their negligent acts that happen. And there's 3 things that has to happen for you to be immune from personal liability. Under the Federal Tort Claims Act. Number 1, you have to be a federal employee. Number 2, you would have caused a negligent or wrongful act or omission. So you did something wrong, but you're still going to be immune. But this act had to occur while acting within the scope of your employment. So 3 things for you to be completely immune from any civil liability. Federal employee, you need to be a negligent act, and we'll talk about strict liability in a minute. And you need to be acting within the scope of your employment. Now, who's a federal employee for purposes of the Federal Tort Claims Act? Officers or employees of any federal agency. So the majority of people here today are federal employees. Military personnel are federal employees for purposes of the Federal Tort Claims Act. Persons acting on behalf of a federal agency in an official capacity, temporarily or permanently in the service of the United States, whether with or without compensation. And it covers volunteers. So all temporary employees are, in fact, federal employees for purposes of the Federal Tort Claims Act. So if they go out on a fire and they do something wrong, they are negligent, they cause some damage, whatever, they're covered also with that immunity, as well as volunteers. That's why it's really important to talk to folks. If somebody's volunteering, make sure you get that volunteer agreement in writing, because that'll cover these folks if in fact something happens. And then ADs, I'm a type 1 PIO. I'm an AD. I still go out. If I do something negligent, I'm covered. Okay. We'll talk a little bit in a few slides about whether independent contractors and cooperators are federal employees, but let's just hold that for right now. And like I said, you did something negligent, duty, breach of duty, or injury. And what they're going to look at is, did the employee, are you negligent? How a court will always look is to say, did you behave like a reasonable and prudent person would in the employee's position? But one thing, I'm just going to bring this up because some states have strict liability statutes, and those do not apply to you, meaning you would never be liable for that if you're a federal employee. Meaning you absolutely have to have fault. You have to find, there's negligence. Strict liability statute would not apply to the federal government. What do I mean by strict liability? It means there's these statutes where society is deemed like there's certain things that are so hazardous that if you do them and if you cause injury, you will automatically be liable. Blowing up things, blowing up things, using dynamite, things like that, that sometimes has been known as strict liability. If you use this stuff and you cause an injury to somebody, you are automatically liable. They don't have to prove that you did it wrong. So the state of Montana has a strict liability statute. And obviously, any person who shall upon any land within this state, whether on his or on another's land, set or leave any fire that shall spread and damage or destroy property of any kind shall be liable. So this statute says, if you set a fire or leave a fire and you cause damage, you're liable. These do not apply to you as a federal employee under the Federal Tort Claims Act. So just, if somebody brings this up, I just threw this in here. Now, I know I said I didn't want to talk about a lot of legal concepts, but this particular legal concept is going to be very evident in about a couple slides. And it's also going to be, it's really important to understand this in terms of criminal liability and involuntary manslaughter when we get there. So I am going to talk about this. This is gross negligent, willful and wanton conduct. This is a heightened negligent. It's like you really screwed up, okay? You just really screwed up. You could have cared less. The key thing was you knew there was an impending danger and you didn't do anything about it. The failure to use ordinary care in preventing conduct after gaining knowledge of an impending danger, or the failure to discover danger through recklessness or carelessness when it could have been discovered by ordinary care. You weren't just negligent, you just didn't screw up. You were just very reckless. So let me give you the example. Let's go back to the stop sign example. You know, we talked about negligence. We talked about that you're driving along and you either didn't see the stop sign, maybe it was obscured by something, maybe you looked down to change the radio, maybe you were just not paying attention and you ran the stop sign, and that's ordinary negligence. But say you had a fight with your boss that day, or you had a fight with your significant other, and you are just madder than hell. And you get in either your personal vehicle or a government vehicle, and you're just speeding along, and you're running stop sign after stop sign, and you know you're running it. You know you're doing it, but you keep doing it. And what eventually happens? You hit the old lady crossing the street. That's gross negligence. You knew, you had knowledge of a danger. You knew what you were doing was dangerous. And you kept doing it. Now, you didn't intend to hit that lady. That wasn't intentional conduct. But you knew about the danger of it. You knew what you were doing was danger. You were aware of your dangerous behavior. And you kept doing it. And as a result, you hit her. That's gross negligence. Case in Michigan, there was another case. I'll just give you another example here. Children playing near an open well on your property. You've got an open well on your property. You've seen kids there. Maybe you've yelled at them, but you did nothing to close it up. You did nothing to prevent them from being there. You knew those kids could be in danger, and one of them falls in the well. That's gross negligence. You could care less. You know what I mean? It's like a recklessness on your part. You were aware of what consequences could happen, and you still kept doing it. Now, why am I telling you about this? Okay, and go back to the idea that we talked about before. The law starts to morph as society starts to morph. And there's greater acceptance, as we all know, with prescribed burning. People understand more today why you need to prescribe burn. And they recognize, society is recognizing that what you have is a very risky job. So certain states only allow a gross negligent action for escape prescribed burns. Florida, Georgia, Michigan, Nevada, and now California. And other states are also considering this. So you could never be liable in those states for just ordinary negligence. You have to really screw up. And that's how the law starts to morph. And there's, like I said, it's helping you. It's working with you. Any questions up to now? Is there something in the chat, or do you have any questions before we start scope of employment?
There's nothing in the chat.
Okay,
Oh, we've got a hand up.
okay, go ahead.
Thank you. Question you had mentioned, I guess is going back to, there's a slide that I think for federal employees, if you're working for the federal government, there's a couple slides back, there's some portion of immunity, I think. Does that apply to like people, if you're on a fire that's a fed fire, if you're a resource ordered to that fire and you work for the state, for example, are you considered a federal employee for the example that you were given?
If you're actually an AD, yes, like there's some state employees that the state doesn't sponsor them and they like take leave and they come be an AD. That's yes. But
Yeah.
otherwise you're probably under but if you're just a state employee, I believe that you're under then your state Federal Tort Claims Act.
Okay. And the second question was, when they're talking about immunity, or I guess kind of liability portion of it, does the concept of qualified immunity play any role in that?
It's complete immunity. I'll get to that. Okay, that's coming. It's complete immunity, and I'll explain what I mean by complete immunity. If you can just hold that, that's okay. All right. So scope of employment. Again, this comes back. This goes back to history. It goes back to what we call the master servant doctrine. And the idea is, it's called respondeat superior, but the idea is when you're at work, the employer has the right to control the actions of the employee if the employee is serving the employer. So you go to work and for 8 hours, the government pretty much controls what you're doing, okay? You do what your boss tells you to do. And the idea behind this whole thing is if you're doing what your boss told you to do, and then something happens and there's an injury, and they're going to come, somebody's going to go and sue you, and what are you going to say? Hey, wait a minute. My employer told me to do it. So the law recognizes that if you're at work and you're serving your employer, whether you work for McDonald's, whether you work for, the government, whatever, your employer is going to be liable for all your screw ups. Okay. That's kind of the idea behind it. The employer should be liable for acts of the employee occurring within the scope of your employment. Okay, could you be at work for 8 hours during the day and your boss telling you what you do and step out of the scope of your employment? Yeah, it does happen. So we're going to talk about what do I mean when I say that how do you stay in the scope of your employment? But one thing before we get there, because we are talking about this concept of respondeat superior and the idea that the employer is responsible for everything the employee does and stuff like that. An independent contractor is usually not a federal employee. And why is that? Because the idea is, again, when you're at work, your employer's telling you what to do. They control everything. They control the safety, they control your hours, they control whatever. I mean, you have discretion, but you know what I mean. But an independent contractor, the US controls the end results, not the day-to-day operation of that person's business. So there may be requirements for an independent contractor. The government employees may come out and inspect and things like that. But in terms of his day-to-day operation, who he hires, what they're doing, what their hours are, how they're exactly doing that job, that's controlled by the independent contractor, and therefore they are not a federal employee for purposes of the Federal Tort Claims Act. And then Cooperators also are not federal employees, and oftentimes your cooperating agreement will actually say that. It'll actually say cooperators are not federal employees for purposes of the Federal Tort Claims Act, and the same idea as of the independent contractor applies. The law regarding scope of employment will apply in the state where the incident occurred, but bottom line, each state kind of goes along with what I'm just about to tell you. Bottom line is the Employees Act has to be incident or in furtherance of the employee's employment. Bottom line, when you go to do something, are you acting for the benefit of the employer at the time of the alleged negligent act, or are you acting for your benefit? So we're going to give you a bunch of examples here. So almost every state looks at these factors. I mean, it's pretty much across the board. Number one, you're within the scope of your employment if the act is substantially within the authorized time and space limit. If they're going to look and see whether you were within the scope of your employment when you did something negligent, they're going to say, were you at the place you were supposed to be at the time you were supposed to be there? So I was on a fire in West Texas many years ago. I was deputy forest supervisor at the time. And there were my hotshot crew from my forest was there too. And for those of you, a lot of people know about this, about 40 miles away from Fort Davis, Texas, where we all were, there's this place called Marfa, and Marfa has these very dark there, and they've got these lights in the sky that people say are flying saucers or UFOs, and everybody wants to go see them. After work one night, my hotshot crew, I didn't know it, left and went to see the Marfa lights. They weren't authorized to leave. They went 40 miles away. They would not have been, if they had gotten in an accident, they would not have been within the scope of their employment. They weren't authorized to go there, okay? They weren't. They were 40 miles away and they weren't authorized to go there. They were not substantially within the authorized time and space limit of where they were supposed to be. So when you're on a fire, don't go drifting off somewhere to go, whatever. You need to stay where you need to be. You need to stay where you need to stay. So similarity of the acts to acts which the employee is authorized to perform. This is somewhat pretty easy in the fire context, because we have our little red cards and it says what positions we can do. What if you're a trainee? Are you okay? Are you within the scope of your employment? Yes, you are. If it says trainee on your red card, you are fine. You're doing an act that you're authorized to perform. So bottom line is, some people have asked also, well, does it have to be in my job description? No, it doesn't have to be in your job description. There's tons of stuff that's not in your job description that you're authorized to perform. But I guess at least in the fire context, my advice is make sure you're doing a job that you at least are a trainee for, or you're authorized to do it. Now, what if you're on a fire or something and somebody turns around, your supervisor turns around and says, can you go do that for me? No one's around and I've got to get this done. And you're just kind of like, I'm not authorized to do that. Well, you don't want to tell him no or her no. So you go and do it and maybe something happens. Are you going to be outside the scope of your employment? Probably not, because but I wouldn't recommend doing this, but there's something called implied authority, and your supervisor implied that you had that authority and told you to go do it. And you are probably going to be, I would say most likely, in the scope of your employment. Because the courts recognize this idea of implied authority. Maybe you didn't exactly say it in writing, maybe that you were authorized, maybe, whatever. But the courts are pretty good at recognizing this idea of implied authority. And the other thing is that the conduct is actuated in at least part by a purpose to serve the employer. Now, what I need you all to understand, because it wouldn't make sense, the whole Federal Tort Claims Act wouldn't make sense. You can do something wrong and you're still serving your employer and you're still within the scope of your employment. Otherwise, the whole thing wouldn't make sense when it says that we're going to cover federal employees within the scope of employment who do negligent acts. If every time you did a negligent act and it took you off the scope of your employment, that wouldn't make sense then. It wouldn't. So let me explain what I mean by this. We have lots of examples here. So there was a law enforcement trainee in a BIA office, and he obviously, as being a trainee, was being trained to draw his gun. And so he goes into the BIA office one day and he said, "Hey, look how I'm learning to do this." And he pulls it out and he accidentally shoots someone. Was he within the scope of his employment? Yes, he was. Court came back and said part of his job was to learn how to draw that gun. He did it negligently, but that was his job. And therefore, he's within the scope of his employment. Another case, there was an Air Force pilot and the plane was going down, and he abandoned the plane too early over a residential area. Now they're taught when a plane's going down that you can abandon the plane, but he did it too early. And obviously there were a lot of injuries. Was he within the scope of his employment? The court came back and said, yes, he is within the scope of his employment. What was he doing at the time of the negligent act? The negligent act was he jumped out too soon. But what was he doing at that time? He was, flying the plane. So he was doing what he was doing. He was within the scope of his employment. He was doing what he was charged to do. He just did it wrong. And therefore, he's within the scope of his employment. Can you be in your scope of employment after work? Yeah, you can. I don't know if you guys have, you've heard about like companies canceling holiday parties because they're worried about liability if people get too drunk and they drive home and hit somebody. You always hear about that. Here's a case of a barbecue after work. This took place at University of Idaho at Moscow. And it was an ROTC, and the commander called the ROTC, about 10 of them in on a Saturday to clean the building on the campus that they used. And so they did that, and around the building too, all that. And afterward, the commander said, well, you guys don't have to stay, but would you guys like to have a barbecue? There looks like there's some stuff in the fridge, and I'll go out and get some more stuff. And 9 out of 10 people stayed. And so they had this barbecue, and afterward they dumped the coals, and they thought the coals were out, and they weren't. And it led to obviously the building catching on fire, and the state then sued the United States for this. Were the ROTC members in the scope of their employment? And you would say, well, no, it was after work and all this. Court came back and said, no, they were within the scope. I said, why? Why? This was after hours. He says, yeah, but you got to look at these social situations. Are these social situations really, voluntary, or is it implied that you should really go? Because if it's implied that you should really go, then I think you're kind of in the scope of your employment when things happen. And then the other thing they said was, what was their job that day? Their job was to clean in the building, around the building. So when they dumped the coals and they went to clean them up, what were they doing? They were doing their job. They did it negligently, but they're doing what they were charged to do as part of their job. And therefore, they were within the scope of their employment. Now talk about this rape case. We're going to talk about LB versus United States in Montana. There was this happened on an Indian reservation, Native American reservation. There was a law enforcement officer, and there was a woman who thought she was at home. She thought her mother was out. She talked to her mother. She thought her mother was out driving drunk. She called the law enforcement officer and said, "Can you please go get my mother? I think she's driving drunk. She's going to hear something. She's going to hit somebody, whatever." The law enforcement officer goes and gets her, locks her up, whatever. And then he goes to the woman's house to report back what happened. And when he was at the woman's house, the daughter's house, he raped her. And as a result of that rape, there was a child. Okay. And first of all, we're talking civil liability here. Yes, the guy did go to jail, but the woman sued the United States and said, "You know what? He was within the scope of my employment. I now have this child. You, United States, needs to pay for this child." And the court came back and said, no, he was not within the scope of his employment at the time. Why? Because originally, when he went to the house to report to her, he was within the scope of his employment. But when he raped her, he didn't rape her for the benefit of the government. He raped her for his own benefit. So therefore, he's outside the scope of his employment. Now, this is one that I think is pretty far out there, this case, but I'm going to show you this one, and then we're going to talk about the Hayden fire, which is a little bit opposite of this. And there are two separate rulings, but this is in the great state of Tennessee, where I am currently. And Malacote versus McDonald's. There was an Office of Surface Mine inspector, and he was out, inspecting mines and doing all this. And he must have been having a really bad day, because he intentionally ran over someone's pet goats, intentionally, while he was out there doing the surface mine inspection. And the court came back and said he was within the scope of his employment. Said the fact that an employee's action may be illegal and even expressly forbidden, because I'm sure Office of Surface Mine does not authorize anybody to go, run over someone's pet goats, does not necessarily remove the act from the scope of employment. The court reasoned he was on the job. This happened on the job. It was in the course of a surface mine inspection. Therefore, he's within the scope. Now we're going to contrast that with the Hayman fire, okay? This happened, those of you that have been around a long time will probably remember this. Those of you that haven't been, I can kind of tell you the facts. This turned out to be at the time, one of the largest and most devastating fires in Colorado history. Multiple homes burned. There was a rec tech on a national forest, and she was on her rounds. She was also a firefighter type 1. And she was getting a divorce, and she got a very disturbing letter from her husband that morning. She was on her rounds, and she stopped at a wreck site, and she was so disturbed about the letter that she started a campfire and she burned it. Then she put the campfire out. She thought she did, and she went on her rounds. And when she came back the same way from these other campgrounds, all of a sudden she realizes that a fire had started. And this fire, as I said, turned out to be one of the largest, most devastating fires in Colorado history at the time. Now, it was very hot, it was very dry, and the forest supervisor had put a prohibition on a lot of things, including starting campfires. Eventually, the insurers of the people whose home burned sued the United States and said, your employee, who was on the job at the time, started this fire, and therefore, should be compensating us because we had to compensate the landowners. for their houses that burned. And the court came back and said, yeah, she was initially, obviously she was on the job, you know, she was doing her rec job. And, you know, when she went to put the fire out, she tried to put the fire out, you know, but it didn't work. You know, she was initially on the job, but when she started that fire in complete, you know, and there was that prohibition on for fires, she stepped outside the scope of her employment. And therefore, you, United States, are not, it was an express prohibition against campfires. So when she went and lit that campfire and burned that letter, she was no longer in the scope of her employment. So obviously this case is the ruling is very different from what just happened with the case with the goats. Talk about two more things and I'll take any questions. I did bring this up before. It doesn't have, nothing has to be in your job description or whatever. But think about it now. What if you know, what if you burn outside a prescription? Do you think you'd be within the scope of your employment? I'd say most likely you still would be, because you're still authorized to do that burn. What if you accidentally lit the wrong burn unit on fire? Let's talk about that. And then we'll talk about being outside the prescription. I'll tell you a little bit of my story. What if you accidentally burned the wrong burn unit? Would you be within the scope of your employment? Yeah, you would be. You can make mistakes. You can do things. Maybe you read the map wrong. Maybe you accidentally burned too much. You thought the unit was this big and it was only that big. You did something wrong. But you're authorized to do it. You just did your job wrong. Okay. The same thing, you're managing a wildfire and the wildfire winds up, you do a back burn and the whole thing winds up burning some people's houses. Happens all the time. You're within the scope of your employment. Okay. You did, you know, you did what you needed to do, but you were still within the scope. You did something wrong. You know, fires are not an exact science. We don't know all the time whether it's going to work or not. We try to get it to work, but you know, if our strategy winds up burning someone's houses, it does, but that doesn't put you outside the scope. For me, what happened to me with escape prescribed burn, we had done 53 burns that year successfully. They came to me and asked me to sign off on a burn. And I had done these variances before. We were within prescription, and but they said that about 2 o'clock, the relative humidities may drop, and they asked for my variance, and I said, sure, fine, okay, we'll do that, because they said we'll be done by 2 o'clock. You know, we're starting this 11 o'clock. We're going to be done, no problem. I happened to be out there that day. Anyway, we lit a test burn about 11. Then we started the burn. And right away it was squirrely. By about 11:45, we were starting to have spot overs. And I'll talk about maybe why. It was squirrely. It was not, the winds were not behaving like they were predicted to behave. And unfortunately, some of the spot overs got into a jack pine unit, which, if anybody knows anything about the sandy soils of the lake states, if you get fire in a jack pine unit, and it wasn't part of the prescribed burn, by the way, it jumped the road and went in there, it's virtually very, very difficult to stop it. It's so flammable. You have to wait till it gets to a hardwood stand. You have to wait till it gets to a break. Anyway, it got in that unit. We called in air resources, started trying to put it out. What disturbs me the most is, when I look back, is that I realized that some of the firefighters had taken chances that could have gotten them hurt. And that's what bothers me the most about this whole thing. But by 1 o'clock, I called it as an escape prescribed burn, and then we got local resources in. We did not we were able to then stop it. And what really stopped it, and I'll tell you, was that from hitting private houses were that we had done a fire break about a month earlier. And when that fire hit it, it just laid down. But, you know, we had to call in local resources. We had to evacuate people. There was an investigation, et cetera, et cetera. Okay. Was I within the scope of my employment? Yeah, I was. I was. So, you know, it turned out that the variance, the relative humidity about 1230 did dip below where it was supposed to. Turned out the way that land laid with the river and the roads, and then that, I think the biggest mistake we made was having that jack pine unit right next to it. But it just tossed up some winds that we did not expect, which, you know, happens a lot. But, you know, so mistakes were made, and they were made on my part, but I was definitely still within the scope of my employment. So, questions?
Trying to get my camera to come on. How does a span of control and how often we are pushed to be outside of that fall within all of this?
Well, those aren't, I don't think, I mean, those aren't like,
Doesn't really apply.
they're not, I'm just trying to think how to say it. I'm not sure that's also written in stone that it would put you outside the scope of your employment.
You'd still be acting within, say, qualifications and so on.
Yes,
But
I don't think there's an issue. I'm not, as a line officer, I'm not recommending all you guys do this, but I do, you know, I have to tell you legally where you stand too. So, yeah, I don't think it would push you. I mean, all these things, all I'm saying is you can do a whole lot of a number of things wrong, and that's what the act is designed to do, is protect you from things that you did wrong.
okay, thank you.
So if you're on a fire and you're a task force leader, your division soup has to leave the line for a couple hours and says, I need you to be the acting division soup. I assume that would be implied authority.
That's what I would say, yes.
That's good, because that's a common thing.
Okay. So what do I mean when I say you're immune from suit? So we're going to talk about the actual logistics. Okay. Because it doesn't mean just because I say you're in the scope of employment and you're immune from suit, doesn't mean that you're not necessarily going to be sued. So all of a sudden you're at home one day and you're sued, you get a complaint served on you, and it says so-and-so versus your name is Joe Smith. And it's about a wild, we'll get out of the prescribed fire thing for right now. And it's about a wildfire that, you know, you were agency administrator on, or you were a fire position on, and they're alleging you're responsible for burning people's houses and negligent. What happens then? You know, because you actually have this complaint against you. Well, the first thing you're going to do, you're going to meet the attorneys. I'm going to tell you right now. So you're going to meet a Department of Justice attorney. And why is that? Because first of all, Department of Justice is going to make the determination whether you were within the scope of your employment, depending on the state that you were in at the time of the negligent act. So usually the first thing you need to do, because there's been people that haven't done this, believe it or not, is tell your supervisor, okay? And then what usually happens, when I was an attorney, was the supervisor would fill out a form that says whether they believed you're within the scope of your employment. That would go to Department of Justice, and Department of Justice would make that determination, okay? So let's talk about first, you're within the scope of your employment. They determine this, okay? So what's going to happen then is Department of Justice is going to make a motion to dismiss you out of the lawsuit and substitute the United States. So they're going to motion, and the court is mandated to grant this motion under the Federal Tort Claims Act. They're gonna say, we're making a motion to dismiss Joe Smith out, and we're gonna substitute the United States of America for Joe Smith. Okay, so now you are completely out of this lawsuit. Yeah, maybe they'll ask you for a deposition or something like that. But you have no liability, okay? So what if the United States loses the case? And they have to, and it's $3 million, judgment. Where does that money get paid from? First of all, it doesn't come from agency funds, okay? It comes from what's called the judgment fund. And the United States Congress allocates money into the judgment fund to pay for these types of things every year. And then the other thing is that you don't pay anything. You don't pay a dime. The United States can't come back on you for this at all. What if the United States wins the case? Can the private party then try and sue you for the damages, for the $3 million? No, they are prohibited under the Federal Tort Claims Act. So bottom line is, the main thing you need to take away from this whole thing for civil liability is, if you are within the scope of employment, you have no liability. You will not pay a dime, okay? You are out of the case. You don't, whether they win, whether they lose, it doesn't matter. You will never have to pay any money as long as you are within the scope of your employment, okay? If Department of Justice makes a determination that you are not within the scope of your employment, it's subject to judicial review. You can get a lawyer, and the lawyer could argue that they were within the scope. And obviously some of the cases that I talked about, the University of Idaho case, all that, they argue about that. Now, this is where if you had, personal liability insurance, that's the one thing you'd want to ask them. If you were going to get that policy, are you going to defend me if they say, if I believe I'm within the scope of employment and they think I'm not? Okay. Now, before I did this, I asked my friend of mine, who's an attorney still for Office of General Counsel, representing the Forest Service, if he had heard of anybody lately in any place that had not been held to be in the scope of their employment. And he had not heard anything. And then he checked with some of the U.S. attorney's offices that do a lot of tort claims and things like that. And they hadn't heard of anything either. I'm not saying it can't happen, but like I said, the system is somewhat designed to protect you. I heard one story of, and I don't know if it's true or not, it's kind of, I heard it third hand, somebody in Region 8 decided to light some burn unit off, like a 1 acre, 2 acre burn unit or something after work one night. They would not have been within the scope of their employment. I mean, obviously, they just went through a match out, basically, something like that. But other than that, you're pretty much, like I said, you're home free when it comes to civil liability in scope of employment. And here's the other practical thing. If I was out here, how many people out here have a lot of money? How many of you have a ton of money? Are you a trust fund baby that you can pay these judgments? You can't. No, most everybody here does not have, $4 million to pay a judgment. And plaintiffs know this. And when I started out and I talked about what's civil liability about, it's about money. So think about it. The United States has the money. So the plaintiff themselves wants you to be within the scope of your employment because they're going to get money from the United States. If you're outside the scope of your employment and they sue you, they might get a $4 million judgment, but let's face it, they're never going to see that $4 million. They want the deep pocket. Questions?
So I just want to make sure I understood. So Initially, it's up to the Department of Justice to decide that you're within your scope of employment. If they decide that you are, then the court can't overrule that.
That's correct.
Okay.
Well,
So
I mean, I guess a plaintiff, I mean, like I said, I guess a plaintiff could come in and say, no, we think he's within the scope. But bottom line is Department of Justice is going to defend you and say, no, he was. A plaintiff can come in and say he wasn't within the scope, but Department of Justice is going to defend their ruling and say, no, he was, number one. And number two, as I just pointed out, the likelihood that a plaintiff's going to come in and say, well, he wasn't within the scope isn't probably going to happen because they're never going to get that money from you. So
okay, thanks.
practically, no one's probably going to do that. Let me put it that way, number one. And number two, if it did do that, Department of Justice, once they've determined that you're within the scope, they're gonna defend you on that ground.
So Leslie, we're seeing a lot of reshaping of our agencies and justice recently. Is there any guarantee that they would choose to make that determination?
Guarantee, well, bottom line is that they have to go by the law. And as I said, I've kind of given you some examples. I mean, they just can't, they have to, their determination has to be supported by the law. So are you within your time and space? Were you benefiting the United States? Were you qualified for your position? All those things, you know, it's not like politically they can ignore all that. They can't. I think that's what you're kind of saying. You know, and number two, it's not in the government's interest to put somebody outside the scope of their employment most of the time because no one's going to want to work for the government. Did I get at your question?
Yeah.
And, you know, they have a whole thing of legal precedent of putting these people in the scope of their employment. So it'd be very difficult to change their mind unless the law somehow changed. And then
I've got one question for you, Leslie. And it's a little bit maybe taking us a different direction. So if it's not the right place, that's fine. But going back to strict liability and kind of related to this, where you know your name would be removed. But I was wondering, with that example of that Montana law or the Montana example of strict liability, where that doesn't apply to the person lighting a prescribed fire or something like that, would it still apply to the agency? You know, like
no,
let's say your name is removed, but that agency is also removed from that example of strict liability in that case?
no, because remember, we go back to the waiver of sovereign immunity, and Congress only waived and said government will be liable only for negligent acts or wrongful acts. The Congress never waived and said we'll pay for strict liability. With the Federal Tort Claims Act specifies the amount that the government's going to pay, and the only thing it's going to pay is negligent acts and wrongful acts. And it didn't say, Congress said we are not going to be strictly liable, because they didn't waive that in terms of their immunity.
Okay. So because they didn't waive it, they are liable. Is that, or am I saying that
they
wrong?
didn't waive it, because the government is not liable.
Okay, thank you.
They have to waive their immunity to be liable. They have to waive their immunity to be liable. The only thing they waived their immunity on was negligent acts. They never waived their immunity and therefore be liable on strict liability.
Okay, got it. Thank you.
Just to I'm going to try and cover this fairly quickly. So, because like I said, once you're within the scope of your employment, you're you're out of the case. But again, you don't hear a lot of judgments that the United States have to pay when it comes to especially wildfires. And that's because you've got powerful legal defenses that the United States can use. One of those is, and I'm going to use this one first, and one of them is statute of limitations. People have to bring their claim to the agency within 2 years, and then 6 months later, they have to file suit. If they bring their claim to the agency, where the agency will decide whether or not to pay the claim or not, if they bring it 3 years, they can't file suit. If they file suit after if the claim is denied by the agency and they have 6 months later to file suit, it's 6 months in 1 day, the court can't hear the case. And then the other thing is what's called the discretionary function exception. And I'm just bringing this up. This is where the United States win most wildfire cases, especially, and prescribed fire. So the idea is when Congress waived its sovereign immunity and said, we're going to be liable for negligent acts, they said every single negligent act of your agencies or only some. And they said, well, we're going to put an exception in where if it's based on the exercise of a discretionary function, the agencies aren't going to be liable for negligence. What do I mean by the exercise of a discretionary function? Okay, so in other words, there's certain things that the government tells you how to do things, okay? You have to do things a certain way. For instance, in the timber realm, we must achieve adequate regeneration after timber sale within 5 years. If we don't, we can be sued for that. We don't have discretion to go 7 years or 10 years. We have to do that. But there's so many things when you go to work, especially in the firefighting realm, that are discretionary. No one tells you how to fight a fire, do they? You've got to think of resource concerns. You've got to think about allocating resources between fires. You've got to think of homeowner safety. You've got to think of firefighter safety. You've got to think of so many things. And we do not have a cookbook telling you how to fight a fire. Everything about wildfire is discretionary. And the courts don't want to get involved in this. They only want to get involved when there is a clear rule and you've violated it. Otherwise, they're saying, we're not going to Monday morning quarterback and say, this fire should be fought this way, this fire should be fought that way. So therefore, when it comes to wildfires, almost everything about them, all the allegations are discretionary, and the courts will not hear these cases, period. Okay, they won't hear the cases. Whether you're within the scope, whether you're not in the scope, they will dismiss these cases out completely. So here's examples. Everything the court said, we won't hear this decision to light a backburn that burned plaintiff's property. That's too discretionary on the part of the agency. Decision not to monitor a wildlife fire at night. Decision to employ less than full suppression strategy. Decision to deploy fire use strategy in wilderness. Decision to light a prescribed fire. Those are all things that you do every single day. And these courts are not going to look over your shoulder and hear that you did them wrong. This kind of sums it up. This is a case out of the 8th Circuit. It says the balancing of the needs to protect private property, ensure firefighter safety, reduce fuel levels, and encourage natural ecological development are precisely the kind of social, economic, and political concerns the discretionary function exception was designed to shield from judicial second guessing. Courts coming in, we're not going to second guess them. There's all these things they've got to consider, and they've got discretion to do it, and we're not going to hear the case. So that's why when you see, even if there are concerns about how to do wildfires and political concerns or not prescribed fires and all that, even if the government gets sued, oftentimes those suits go away because the courts don't want to get involved. If there was any discretion on your part, and everything in firefighting to me is discretionary. You've got your watch out orders, you've got your all that, but courts have said that's not hard and fast rules. You know, they're not something that took away complete discretion. So with that, that ends civil liability. You all need a break here. Take a how long do I
Yeah.
have to go for?
I think 10 minutes is probably
Okay.
good.
Can we do that?
We got 10:20, so back at 10:30.
Thank you. Okay. Okay, so I can start. Okay.
Yep, there you go.
All right, criminal liability. Let's talk about that. We're going to talk about two very diverse cases, okay, and explain the difference between them and what you could do on each of these. One is the 30-mile fire, where IC L. Reese Daniels was indicted on 4 counts of involuntary manslaughter and 7 counts of perjury relating to his role as IC on the 30-mile fire, where 4 people died. And then the second one is the burn boss charged with Class A misdemeanor of reckless burning relating to his role as burn boss on a prescribed burn. So remember when I said, excuse me, at the very beginning, that there's different rules between civil liability and criminal liability and administrative sanctions. So just keep that in mind as we go through this. So the first one I want to talk about, we're going to talk about the 30-mile fire, okay? And I'm just going to sit here and talk a little bit about what happened, for those of you that maybe some of you are very familiar with it, probably more familiar with it than I am. But the first thing I do want to say is I'm here to give a legal opinion on what happened to the IC and the sustainability of the involuntary manslaughter charge against him. That in no way do I want to say that this was not a horrible tragedy, okay? 4 people, 4 firefighters lost their lives. 3 of them were only like 18 or 19 years old. I mean, it was horrible, okay? But whether or not that IC should have been charged in the first place, and he certainly was never found guilty, that's what I'm here to talk about. So back before, we talked about gross liability, willful and wanton conduct, and the failure to exercise ordinary care in preventing conduct after gaining knowledge of an impending danger. Why am I bringing this up now? Because L. Reese Daniels was charged, the IC was charged with violation of the federal criminal statute 18 U.S.C. 1112, involuntary manslaughter. The elements were that number 1, it was an unlawful killing without malice or intent. Yes, he did not intend to kill these people. Gross negligent or wanton recklessness, what I just talked about. The fact that the actual knowledge that his conduct was a threat to the lives of others. So again, talking about this, back to gross liability. Did he fail to use ordinary care in preventing conduct after gaining knowledge of an impending danger? Did he know that his actual knowledge, the actual knowledge that his conduct was a threat to the lives of others? So let's talk about what happened. Small fire started out, I think it was a type 4 in a canyon, Eastern Washington. This was not the big show that day. The Libby fire was the big show that day. But things just started going wrong from the beginning. It was like, you know, we talk about the Swiss cheese and the holes, and it just, one thing after another started going wrong, including trying to find an IC for this fire. And all these things went wrong. Somebody's phone was off the hook, it turned out. They never got a hold of him. Finally, they call Al Reese Daniels. Now, he was qualified, but he didn't have a very strong leadership presence. He had fought fire, he was qualified, but he was soft-spoken. It was hard for him, I think, to get control of everything. He just didn't have that presence. Things started going wrong from the beginning. There was a river, I mean, that was running right near this fire. I mean, it would have been, go in, bring the engines in and let's, put some water on it. I mean, that's the way it should have been. And it wasn't, for a number of reasons. The pumps didn't work. I mean, there was all these things that went wrong. Communication was just not working. There was a helicopter that could have helped them that sat on the runway for I don't know how many hours. Lack of communication. People didn't know that there was no outlet to the canyon. And this fire was just the way, I read the report, I've read the book. It was squirrely. It seemed like it was laying down and you couldn't see it. And all these swirly winds were coming in. And anyway, it got under control. It got out of control, and it started to become evident that 14 people were going to have to deploy their shelters. The IC found the safest place. It was kind of near it was on the bend of the river where there was actually like not a lot of vegetation right near that river. And he kept telling people also, he was right by the road there. The way he kept telling everybody, deploy on the road, let's stay near the road. Whether he said deploy near the road or stay near the road, that's up for grabs is what happened. But this fire came in, and I'm leaving out a lot of facts, and I'm sure a lot of you know them, but this fire came in, they had to deploy. There were 4 people that deployed on a scree slope, not more than 10 feet from that road. But the way that fire came in and it almost settled right on those 4 people on a depression or whatever and killed them. Everybody else survived. At the time, so he was brought up on charges that he should have gotten those 4 people off the road. That was really it. And so that he was brought up on those charges. The bottom line is it was such a commotion. There were so many things wrong. There were so many things that had gotten done wrong. He was trying to talk to the helicopter, I think, trying to still get some drops on it. He didn't keep track of all these 14 people, it just wasn't done in a real structural manner, this deployment. And he claims that he told them to get off the scree slope, but obviously he missed that they didn't. There's some people that says he never told them. There's some people that said that maybe that he told them and they didn't do it. It was just kind of a complete mess at that point. And he's trying to talk to the helicopter and all these things are going on, and he misses that they're there, and that's who gets killed. Okay, so it was a tragedy. And but you look at it and you say, I have to say to myself, did he really act with gross negligence? Did he really think of that person that we talked about, that stop sign, running the stop sign. He knew he was doing something wrong. He knew he was doing something wrong, and he continued to do it. The stop sign example. Here, did the IC know that he was doing something wrong and he continued to do it like he just could have cared less about these people? No. And I remember reading this whole thing, and when he was charged, I remember saying, this cannot stick. This is ridiculous. It doesn't meet the elements of the crime. And you ask, well, why did it happen then? And he was charged. The real travesty was he was charged 5 years after this all happened. Well, why did it happen? Did the agency want it to happen? Did the agency say he should have been charged? The Forest Service? No. But it's not the Forest Service's, it's not any agency's say. It's the United States Attorney's prerogative. That person is appointed, okay? And here's this, and you got to think about him, about that U.S. attorney. He's hearing these, these parents saying, my God, my kid's been killed. Somebody ought to be paying for this. So he gives in and he charges Ellery Daniels for it, okay? So what happens when you're charged with a federal crime? So first of all, I always said you get DOJ representation in civil liability, right? When you're in scope of your employment. Well, here you get legal representation by Department of Justice, may be granted upon request when the actions reasonably appear to have been performed within the scope of his employment, which he was within the scope. I mean, you're trying to manage a wildfire, but the second part, and when providing representation would otherwise be in the interest of the United States. He is being brought up on federal charges. The United States of America is prosecuting him. Therefore, it's not in the United States' interest to defend him. So when you're brought up on federal criminal charges, you're not going to get a Department of Justice attorney. You're going to have to pay for your own attorney. And that's where your your liability insurance comes in, that you might want it. So he had to get his own attorney, and he was brought up on that. I just forgot one other thing I was going to tell you. So in the end, what did happen was the manslaughter charges eventually were dismissed, okay, because they couldn't stay there. So he pled guilty. They said he lied. I don't know if he did or not, about telling the people, the firefighters, to get off the slope and some other things. So he wound up pleading guilty to 2 misdemeanor charges relating to perjury. He did 3 years probation and a 90 days work release program, and he got to keep his federal job, but he could never fight fire again. Now, that's what I meant to tell you guys. The most important thing, and as a line officer, I'm going to tell you this. As a line officer, I'm going to tell you, they're going to ask you what happened. If in fact you ever get yourself in a situation where somebody has died because of a decision that you could have made, or someone has gotten severely injured, the agency, first of all, is going to want to know what happened. And they're going to tell you, you've got to tell us what happened. But I'm going to tell you also that 5 years from now, they can use your own words. That U.S. attorney can charge you based on what you told the agency at that point in time. So what you need to do, I know the agency wants to know what happened. We need to learn. We need to figure it out. But if you find yourself in that serious of a situation, get yourself a lawyer right away. And what you want to do is you want to get immunity, that your statement is not going to be used against you if that U.S. attorney 5 years later decides he's going to charge you. You've got to do that. The unions have tried, I know they have tried in the past, to try to get some kind of legislation in place where people, federal employees can talk and it's not going to be used against you. But bottom line is, it's not there right now. And all I'm going to say is, if I was in charge and somebody had lost their lives and their agency was going to ask me, I'd get myself a lawyer right away. And I'd try and get a deal. I'd say, I'm not talking until I get some kind of immunity here from 5 years down the line. Same thing happened up in Kramer. Again, you got to look at this. I just don't see how some of these charges, these involuntary manslaughter charges, can stick. In Kramer, that was after 30 Mile. Same thing happened. The guy was going to be charged with involuntary manslaughter. And in that case, there was 2 firefighters that had been dropped off on a ridge, and they were going to clear a helispot, and they'd been up there for a while, And they kept saying, "Are you guys okay?" "Yeah, we're okay. We're okay." He actually flew it at about 1:30 p.m. that day, looked at it, said, "Are you guys okay?" "Yeah, yeah." It said, "Well, I think there's a spot, kind of below you, could hit you." At 2:30, he called him again. "Are you guys okay?" "Yeah." He says, "Well, we're sending a helicopter in to pick you up." Bottom line is, helicopter didn't get there in time and they died. Was he really guilty of gross negligence? No. Let's face it. He made a mistake. He made a big mistake. Okay. He should have picked those firefighters up earlier. He miscalculated. But to say he acted with wanton recklessness such that he would be, he was guilty of involuntary manslaughter, I don't think you are. When you're out there and these tragedies are happening, you're trying to manage all sorts of pieces and parts. And all these ICs did was they missed one part. And that's not knowledge. That's not being careless, like they could care less about these people. That's not knowledge that what they were doing was going to, cause those deaths. No, none of that. It's just they missed a factor, like everybody can do every day. So any questions on this? Okay. So now we're going to talk about a completely different situation on criminal liability. I believe it was 2 years ago, a burn boss in Oregon, they were out burning, doing a prescribed fire in a county that's very anti-government. And there was a slap over onto private land. They were getting it, but there was a lot of private parties that were harassing him that day and their people. And he called the sheriff and he said, "Could you please get these people out of the way? We're trying to handle this slap over, et cetera, et cetera." The sheriff came in and instead of getting the people out of the way, he arrested him on site. And he was charged with a violation of Oregon state law for reckless burning. And it was a Class A misdemeanor that carries a penalty of up to a year in jail and a $6,250 fine. Oregon state law says, that you can be charged with reckless burning, and reckless burning is defined as if the person recklessly damages the property of another by fire or explosion. So this was really the first time this had ever happened. And, we're all kind of wondering exactly how this was going to go. Well, he got charged with it, but it took a year and a half to actually indict him, which was a long year and a half for that burn boss. Okay. Meanwhile, what happened? Okay, we talked about it. With criminal liability, you have to be within the scope of your employment, and it has to be within the United States's, it's their interest to defend you. And then they'll defend you. Okay, well, here's why they felt that it was within the United States's interest to defend him. He was within the scope of his employment. He was carrying out a mandated federal program, an important federal program, prescribed fire. Okay. So it was in the United States' interest, it's in the Forest Service's interest to make sure that their employee is not going to jail for something that they told him to do, and that he was within the scope of his employment. So they got a private attorney for him. And you might say, well, why did they get a private attorney? Well, this is my guess, but I'm pretty sure I can read the tea leaves here. First of all, they're an Oregon state court. And so therefore you need somebody with an Oregon law license and somebody that's used to the Oregon system and the judges, et cetera, et cetera. And the other thing is, if this guy is indicted, can you think about it when you're sitting in one of these anti-government counties here, that some DOJ Washington office lawyer comes in and tries to defend him, what's that going to look like to a jury? It's not going to look very good. You want to paint this guy as, you want to paint him as a local guy. You want to paint this as a local manor with the anti-government sentiment that's in this county. So they decided that they would hire him a private attorney, a private Oregon attorney, and USDA Office of General Counsel paid for his attorney, probably because they were authorized to do so and the Forest Service wasn't. That's what I'm guessing, but I don't know for sure. So it took a year and 4 months to indict him. And unfortunately, I think why there was no movement by the government on this case to get him out of the case was they had to wait for the indictment. So once they got the indictment, what they did was they moved the case to federal court. They removed it to federal court because it involved a federal employee, and the case was dismissed. Why was it dismissed? Because the burn boss, because of what's called the Supremacy Clause of the United States Constitution. And that says if you've got a state law and you've got a federal law and they conflict with one another, or a state law and a federal program and they conflict with one another, the federal law is supreme, and that's the one that you go by, and the other one falls by the wayside. So in this case, for instance, the federal program was supreme over the Oregon state law, and therefore the employee could not be charged with that because he was lawfully implementing a federal program at the time, and therefore the charges had to be dismissed. And the state's attorney for the state of Oregon, for that particular state's attorney for the state of Oregon agreed with that. It's like, for instance, I'll just give you another example. You've got the Federal Endangered Species Act, and a lot of times you've got State Endangered Species Act. Say you're a researcher and you get a federal permit from Fish and Wildlife Service to remove 5 endangered plants, and the state comes in and says, you can't do that. We're going to hold you liable under the state law. And you're like, no, the federal law is supreme, and I've gotten this permit under it, and therefore I cannot be liable under the state law. So that's what happened. That's why, he was lawfully engaged. Number one, the key thing was he was charged under a state law, and he was lawfully engaged in a federal program. And that gave them the opportunity to just move it to federal court and dismiss the case against him. So 2 opposite things. The others, the ICs, Ellery's Daniels, the other one from Kramer, both were charged with federal laws. And in Kramer also, the cases were dismissed against him. And he didn't do any time or anything. He did resign from the Forest Service, I believe. So there, you've got that. You've got the charges of federal law, and then you've got the charges of state law. And again, when you've got the state law charges and they conflict with a federal program, this is likely what would happen to you. Questions? All right, the last section real quick is just administrative sanctions. These are the things that your own agency can do to you: a letter of warning, a suspension, losing your job, those kinds of things. So I was asked on break, and I thought it was a great example. A person asked me that guy that ran over the goats, could the agency still have suspended him or fired him or done anything for him, done anything to him like that, even though he was in the scope of his employment? Absolutely. Scope of employment is pretty irrelevant when it comes to administrative sanctions. And in fact, you certainly could get an administrative sanction for something that didn't happen that happened outside the job. The easiest way, when I was a forest supervisor, I'll be honest, the easiest way a firefighter can lose your job is if you've got a CDL license and that's a requirement of your job and you get a DUI and they revoke that CDL. I did have someone that happened to me. I had an employee that happened to, and he was going to lose that CDL only for about, it wasn't that long, for maybe like a month and a half. And I had to argue with HR not to fire him. You know, it worked out fine. The guy never had no DUI or anything like that. But that's the first thing they come in. If you lose that CDL on a DUI, you can lose your job real easy. And it doesn't matter whether it happened. It certainly wouldn't have happened on the job. Hopefully not. You weren't drinking on the job. It could have happened at the bar on Friday night. But scope of employment's irrelevant. And here's the other thing is government attorneys are not going to be your attorneys in these cases. If the agency moves to fire you, you're not going to get a government attorney defending you. So this is very important that you, when you get a if you get a personal liability insurance policy, make sure it has an administrative provision that will defend you in administrative proceedings, especially line officers with EEO, well, anybody with EEO claims and things like that. You definitely need to make sure that your policy covers you for, you know, administrative proceedings, because government attorneys are not your attorneys in these cases. Now, having said this, I still go back to, you know, we are going, you know, at least, you know, the Forest Service, and I imagine other agencies are getting away from this kind of investigative culture and trying to get back into a learning culture. You know, what did we do wrong? Yeah, when I lost a burn, yeah, there was an investigation team, but, you know, I never worried that someone was going to slap my hand. You know, I was going to get some kind of letter of warning. I never did. And nothing happened to my burn boss, because we're here to try and just learn. And plus, you know, if, you know, I get something, if I get suspended, my burn boss gets suspended, who wants to do our jobs anymore? Nobody. So the agency really is moving away from that. I can't say you'll never get an administrative sanction. So you know, I need to tell you all these things, but still, I think the agency is trying to move away from these types of things, especially in the fire realm. Questions?
So Leslie, I've had a question that's been sort of niggling at me. As long as employees are working within the scope of their duties and responsibilities, they don't really need personal liability insurance. And so as a line officer, you're giving advice to your FMO or to a burn boss. Is that sound advice that personal liability insurance as an extra cost is not needed?
Okay, so everyone asked me, do you need personal liability insurance? It depends on your risk, okay? For civil liability, if you're within the scope of your employment, nothing's going to happen to you. But as I just went over, if it comes to something criminal, if it comes to something administrative, you may be employing an attorney if something happens to you. And so that's what you have to be concerned about. Those are really the risks, I think. It's not so much civil liability as your risk. Unless you're way out there, you're most likely going to be within the scope of your employment. But when it comes to criminal liability, if you're federally charged, you kind of got yourself stuck. And administrative proceedings. So what's your tolerance of risk? What's going to let you sleep at night, and what's going to let you do your job? Because you are going to have to take risks. That's what I ask you all. I know the agency pays half for a lot of positions. When I left, it was like $300-400, but I didn't have it, but I know that's what it was. Although I think last year I did have an IC tell me at one point in one of these sessions that For ICs, they were charging $900. So agency pays $450 and you pay $450 a year. But, you know, read your policy, ask questions, and, you know, ask these questions. If I'm not held within the scope of my employment, are you going to come in and are you going to help me defend myself, you know, in terms of if I think I am within the scope? What happens on criminal charges? You know, what happens on administrative? Is there administrative proceeding? Read the policy and make sure you're getting what you need. That's all I'd say. So for civil liability, if within the scope of your employment, you're not personally liable for your alleged negligent acts. And if a court finds that liability for your negligent acts, the United States is going to pay any judgment. No problem. In criminal liability, summing it up, if you're charged with a federal crime, the United States will be prosecuting you and you'll have to employ your own attorney. If you're charged with a state crime and are deemed to be within the scope of your employment, the case could be removed to federal court and charges dismissed if the state law conflicts with a federal program that you were engaged in. And then finally, administrative sanctions, scope of employment may be irrelevant, and you'll have to employ your own attorney, although agencies are embracing a learning culture versus a disciplinary culture. So hopefully these things wouldn't happen to you, but you know, that's where it's at. The only people, and I don't know if there's anybody in the room, the only people I will always definitely tell you need personal liability insurance is law enforcement officers, and that's because they face some different things than you and I face. They really needed to have liability insurance. But other than that, it's really what's your tolerance for risk, you know, and what's going to make you sleep at night.
Hey, Leslie, there is a question, or somebody's got their hand up, I guess, maybe. So
Okay.
go ahead.
Hey, Leslie, thank you very much for this. Is very informative. I was in a Burn Boss workshop just a couple weeks ago, and there was a similar presentation, and I was just curious what your thoughts are on the recommendation for liability insurance. It was in the context of the Snodgrass case here in Oregon, and they were saying there were some questions about, you know, it seemed like it took a few days to weeks. It was kind of unclear on how long, but for the federal government to decide to step in and take over the case for Snodgrass. And that lawyer was basically said that would be, in their opinion, the best reason to have personal liability insurance for that gap between, you know, when you may be arrested and when the government decides that, yeah, you were in your scope and that they're going to step in and defend you. Would you agree with that, or do you think that gap isn't really as
I
big
agree. I agree.
Okay.
I mean, you know, this person obviously was, I actually personally talked to him. I mean, he went through a lot. Number one, because it was a case of first impression. And you know, I was just kind of, I think all of us were just kind of, I'm not in the inside of the government anymore to tell you, but so I was just guessing from the sidelines what was going to happen. And so, you know, I think that person the Burn Boss went through a lot because he didn't have an attorney right away. And it was a case of first impression. So you're wondering exactly what's going to happen and how's it going to happen. You know, so it wasn't. And then, like I said, the fact that it was 1.5 years before they indicted him. I mean, that was like, oh man, living with that, living in the community, all that, you know, just kind of being out there and waiting. It was just, I agree. I mean, it would be good if he had an attorney. I don't know if he did or not.
Thank you very much. Appreciate that.
I also heard on, it was the Albert Pike case that had to do with flood that killed a lot of people in Arkansas. I had heard that for some reason, Department of Justice took quite a while to dismiss them out of the case, and that person had concerns there as well. I don't think that's normally the case. Normally, I mean, these things go pretty fast. I've kind of seen it, you know, when I was an attorney. I thought it went pretty fast, that they just move in and everything like that, but I guess at times it could take a while.
Okay, are there any other questions for Leslie?
If you all have any other questions, you are certainly, there's my dog again. You're certainly willing to email me. I'll answer them to the best I can. And it's been a pleasure being here, and thank you.
Thank you. With that, we're at next scheduled break. We're about 5 minutes behind. Is that all right, Eric, to take a full 5 minutes, or do you want to get into the scenario right at 11:10?
Yeah, I think we can give them the 10-minute break that we had
Okay.
scheduled, and then we can start up, do this, and then we're gonna roll into lunch and break. So we'll have some additional time to take care of stuff there.
Okay.
For folks planning purposes, Matt, you wanna plan on we'll be back in 10 minutes. We'll do the scenario, and then we'll be back with starting up at 12:30, or you want to do 12:25? People be back from lunch for.
Go back from lunch. Well, we'll just kind of have to, yeah, we'll have to see. I think
Okay.
that'll probably work. So
Okay. Yeah, let's plan on, so for folks that are trying to plan missions over lunch and stuff, we'll be back here, we'll do scenario in 10 minutes, and then we'll do our lunch and scenario break, and then be back in class for the post fire at 12:25.
Okay.
See you guys.
work.